suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And joining us to answer your legal questions is David Whiting. He is a Melbourne solicitor. Good morning, David.
Good morning, Raph.
You are coming to the 100th birthday party?
Indeed, I am.
You got some tickets?
The tickets are on my phone and on the fridge.
On the fridge?
And it's locked out in the diary.
Oh, very good,
Okay.
very good. And you have been to celebrations like this before, you were saying?
I was lucky enough to get an invitation to the 25th.
75th.
75th, sorry.
25th, I'd be really impressed.
Yeah, I would be too, yeah.
The 75th?
The 75th. It was a dinner.
Right. Was it a radio show or was it just a celebratory dinner?
It was just a celebratory dinner.
Wow.
But I tell you, the best thing I went to was that you had a performer, a Canadian singer, can't remember her
Katie
name.
Lang?
Yeah, Katie Lang sang in the Iwaki
What did she sing?
Auditorium.
Was that?
She did an evening program.
It was a part of
It was a Derek Eel
Eel's
program.
evenings program.
It was
yes.
just amazing.
I think I
Best thing I've
remember
ever
that.
been to.
Oh wow!
Yeah.
Ever?
Yeah.
Best thing in your life was an ABC. It was a 774
Right, no, the best.
event.
Let's call it the best function I've ever been to.
Okay, best
Yeah,
function.
yeah.
Okay.
Yep.
Um,
Otherwise, I'll cut my family out and I'll get into real trouble.
well, yes. Lachie Neale, the Brisbane captain, was asked how it feels after the premiership, and he was sort of on the ground, with his foot in a moon boot, drinking a beer, saying, "Well, I better tell you. I better not tell you it's the best thing I've ever done that's ever happened to me because my wife will be listening." But
it's close.
Yep. 1300 222 774 is the phone number. If you've got a legal query for David Whiting, don't ask him if you've got a ticket at the 100th party. Do ask him now. Colin is in Flemington. A reminder, if you're a first-time caller, you go into the draw to come along to that party on Friday week. Colin, what's your question?
Morning, David and Raph. I've invested some money, inherent money that I think was with a rather dodgy financial company. It was a fixed income term deposit for a period of 5 years, and it was due to mature this month. The initial
Have you been
investment-
getting the instalments of interest, Colin?
Yes, I've got monthly statements from day one.
Yes.
Up until about 2 months ago when they seemed to stop. The problem, I think, with the company was that they had another investment arm that was seeking to develop a Queensland island resort, and ASIC took a dim view of how they were doing that, and they appointed administrators and told the CEO he couldn't perform that role anymore.
Right.
So what's happening now is with the investment due to be redeemed, I'm unable to locate the company. Their phone numbers.
Can I suggest ASIC? asic.gov.au.
Right.
The first thing you're doing is you're searching for the name of the company.
That's right.
All right. Now, and you might, if you can't find it there, you'll have an Australian company number, and you might search on that. You can also go to abr.business.gov.au and search the Australian business name number register.
Right.
And you might find whether they still exist or don't exist. If they don't exist, but you've been getting interest till incredibly recently, so my view is they still are, although they're likely to have changed their name.
Right.
Right. And if you do the company search on the on the Australian company number, you'll actually then be told if the name has changed.
Right.
Fairly good system, and that's where you start. You might then also, if you're satisfied with where that takes you, about $10 or $12 on the ASIC website will get you a current company search, which will show you their registered office and their principal place of business and the names and addresses of their directors.
Oh, very good. I mean, I went to their current business, which they advertise on the web still, and that's no longer their place.
So you mean the physical place or the thing online?
Yeah.
The online address is no longer their physical address. Yep.
Yeah.
You knock on the door and find out if anybody knows where they've gone?
Yeah, no, they said they hadn't been there for about 3 years, which is a worry.
Okay.
Okay.
All right, if you then don't get what you want, I want you to talk to the Australian Financial Complaints Authority, AFCA, and because they will be required to be registered and to deal with your complaint. But if you start with a company search, you've then got a better idea of where to look next, Colin.
Okay.
Right. Okay, good on you. Thanks very much, David.
Good luck, Colin. I hope you resolve that. You begin with AFCA with a complaint like that, wouldn't you, David, once you've got some details?
Yes, but you've got to be able to identify.
Understood.
So to me, the identification was Colin's bit. Yep, but then AFCA.
Understood. If you are a first-time caller, let us know. You will go into the draw for the tickets for our great, big, fun show Friday week. Jake is in Braeside. Good morning, Jake.
Hi, Jack.
No,
Hi,
you're Jake.
David.
Yeah, hello.
How are you?
Very well.
Jack here, and first-time caller off. So
Okay. You go in the draw as well. We'll get your details while you... Don't go anywhere once we finish with you. We'll get your details. What's your legal problem?
Issue David, I bought one business which used to, that building also used to be owned by that same owner. So first he sold the building and then he sold the business. I was the part of employee of the third business only who ended up buying that business. But the question is that when that previous owner had a solar panel on the building.
Yes.
So obviously he purchased on the name of company.
Yeah.
So obviously company was paying $1,000 a month kind of thing, whatever solar panel, the installment.
So they had a financing arrangement for the solar panel. Yeah, what's the question?
Correct. Question was when after 5 years lease expire, when I'm vacating building, so pretty much then obviously we thought because we paid $60,000, $70,000 for the panels plus difference in the bill probably $500. So we were out of pocket nearly $1,000.
So you're paying the fees for the solar panels and you rent the building, is that right?
Correct.
Right, and you're paying the fees. There's a financial plan for the solar panels.
Correct. And when I'm vacating buildings, so I was
There's two parts to the answer, Jake. If you are renting the building from the building owner, there may be something in the contract that you've got with the building owner relating to the provision of the solar panels for Power for You. There may also be something in the sale of business agreement which makes you responsible.
Nothing mentioned in either of them.
Then in that sense, then, Jake, the solar panels have nothing to do with you.
Okay, so that panel belongs to the previous owner.
Unless there's something in the contract of sale that makes the solar panels yours, they belong to the landlord, whether it's the new landlord or the old landlord.
Okay, so whatever amount we have paid out of pocket, are we able to ask them to pay us?
If you've paid someone else's debt, you can ask them to pay it.
Okay.
All right. So if you've paid the previous owner or the current owner's obligations to the finance company for the solar panels, you can come along and say, I've paid your debts by mistake. I want you to reimburse me.
Have you been using the electricity from the panels, Jake?
Well, the issue was Ralph, the electricity was going to the 3 different people. And the whole we were paying for electricity for everyone. So probably we were paying $2,000 electricity. Out of that, probably $500 was ours, but $1,500 we were paying from other people. But they were not paying full, so pretty much
so you were paying most of it, if not all of it.
Most of the heat we were taking.
There's also an issue in relation to outgoings from multi-tenanted building, and who gets to pay what. So, Jake, read the documents really carefully, and it seems to me as if you're entitled to some money back. You might also talk to the electricity company about getting the 3 tenancies separately metered.
Yeah. Okay, good luck, Jake. Thank you. Hang on a tick. We'll get your details and put you into the draw. Leslie is in Surrey Hills. Leslie, what do you want to ask?
Hi, Raf. Hi, David. Thank you for taking the call. My question is about the costs that a lawyer can ask you to pay when you have not given instruction for this. Now, very simply, I was asked to be a litigation guardian for my granddaughter, who is 10, and I agreed to this. And I was also advised by the lawyer who was dealing with my daughter-in-law, because this is about a will.
Yes.
To get myself a separate lawyer. Now, this all happens in Tasmania. So I got myself a Tasmanian lawyer. And things were going along kind of okay, slowly, but going along okay. And then he had filed the initial document which said that I agreed to be the litigation guardian. And then he disappeared, left the firm. And
Can I say, Leslie, technically your engagement is with the firm, not the individual. The other thing I would say is that there there's a thing called the Legal Profession Uniform Law, which isn't quite uniform. It's certainly in Victoria, New South Wales, Queensland and South Australia, and it may be in Western Australia and Tasmania, but I'm not sure. Now, under the uniform law, and it's a fairly close guide to what it is in the other states, is that if I am going to charge you $750 or less plus disbursements or out-of-pockets, then I'm not required to give you a costs agreement. If I'm going to charge you $3,000 plus GST and out-of-pockets, I've got to give you a short-form cost agreement. But anything over that, the firm is required to give you a cost proposal that you are required to accept. Now, I would have thought that as the litigation guardian, you would be expecting someone else to pick up the bill.
Well,
so,
yes, but the bill has become excessive because they have gone beyond what their brief was as far as I was concerned.
Well,
and there's a new lawyer who came in months afterwards. Nobody has been communicating with me, and suddenly there's a new lawyer who has gone to take the matter to court. And the matter was very simple. Everybody was in furious agreement that there was a problem with the will, and it just needed,
But presumably there was no furious agreement about what the outcome was going to be as a consequence of the problem.
Oh, yes, there was furious agreement. Everybody, we had affidavits from the friends of the deceased and her brother and...
So ask Leslie, I don't understand, why is it going to court if everybody agreed?
Well, I didn't understand this either, but it didn't actually, I think it only had to have paperwork filed, but there was a chance that the judge would then say, we need to hear from people. And I don't understand any of why.
Sometimes with the will, it has to go through the court?
It depends. If there is a person with a disability, in this particular case, Leslie's granddaughter is a minor, and in those circumstances you need the court's approval to whatever compromise you reach. But I've just finished one, Raf, where my client has a disability, and so we've settled, but it's settled subject to court approval. I now need to make an application to court to persuade the court that the settlement I've reached is in the best interests of the represented person.
So that's
Leslie's issue. Well, no, if I'm a litigation guardian for a grandchild, it's got to go to court but it's only got to go to court for approval. So I would be, if I was Leslie, I'd be going along and saying, I want a detailed explanation as to how I got where I am now, and then tell me what else it's going to cost. And I would then be talking to the daughter-in-law, the child's mother, and saying, why am I getting this bill? But I would also have thought that the expectations of the litigation guardian, who to all intents and purposes is the granddaughter, so let's consider them as one legal entity, all of the costs in the normal course would come out of whatever the court decision was. Yep. So you need the explanation, Leslie. If you're not happy with the explanation, then there will be a legal industry ombudsman, there will be a legal services board in Tasmania. Complain to them.
Okay.
Okay, so I think I'll have to go So the legal services board are the people
They're the people in Victoria. I don't know what their equivalent is in Tasmania. But Leslie, let's make it really simple. If the matter has settled, there still needs to be a court approval, because the court takes on a parental supervisory role for infants. So you and everybody else may have been in agreement about what happens to your granddaughter, but the court comes along and says, hang on a minute, that's our job. We'll look at what you've done. There's a very good chance we'll approve it, but we need to see it first. So that could be why you're going to court.
Good luck, Leslie. Thank you for calling. David, someone's pointed out in the text, if the KD Lang 774 event was the best thing you ever went to, that means it was better than John Fane's farewell.
Oh, see, there's the problem. There is the problem. The farewell was fantastic.
There you go. I'll let John Fane pick that bone with you next week.
No T-shirts in my size, but what can you do?
What can you do? Mary is calling from Emerald. You're a first-time caller as well, Mary.
Yes.
Oh, how exciting. We'll put you into the draw. What's your question?
Okay, so my husband and his siblings inherited their mother's house about 10 years ago, and one of the siblings lived in the house up for that 10 years until it was sold recently, do they have to pay capital gains tax?
You haven't given me enough information, Mary, so here we go. All right? Okay. I take it that the property was your mother-in-law's property, that it was her principal residence for all the time she owned it until she died?
Yes.
Okay. And did the will give a family member a right of residence, or was that the agreement reached between the family?
Agreement reached.
Right. Okay. In that particular, and how many siblings are there?
4.
Rightio. So for 3 of the siblings, they will be deemed to have acquired the property on the date of your mother-in-law's death at its then market value. Mm-hmm. Right? For the person who lived in it as their principal residence, that person will not be paying capital gains tax because they're an owner and they live there. It would be a little bit like you and I owning a property that you live in and I don't. I pay capital gains tax, you don't. Yep. All right? So for 3 of them, so what you need to do is be satisfied that you've actually got the market value of the property when your mother-in-law died.
Okay.
So some people, there will have been a figure put in the probate application. That could be the capital improved value from the council rate notice. It could be a formal valuation. It could be a wild stab in the dark. But from
is there a 2-year grace period or something that?
Yes.
Or does it?
Yes, there is a 2-year. So in the event that the property is sold within 2 years of the date of death, then the law says, well, we'll assume that it was worth the same constantly through the 2 years and we'll accept the sale price as the date of death value.
Okay.
But in the event that you go over, and it's possible to get that period extended, but it doesn't, you can't make the application until the property's sold, and for the life of me, I don't see you're going to get an extra 8 years.
Yeah.
So
how do we determine the value? Do we use the council valuation?
Well, my experience is that council rate notice values are fairly close to right now, but 10 years ago they were definitely not close to right. I would be looking at a valuer who would give you a formal appraisal based on property transactions that are around the same time and the uniqueness of the property, and will tell you that on the day your mother-in-law died, the property was worth X.
And that's an accountant question and not a lawyer question,
That's
I guess.
a valuer question, not an accountant
yes.
question, yes. So
but you could go to an accountant to do the whole.
Yeah, to implement what the valuer gives you, yes. But you've got to look and see what was the calculation done, how did we get to the figure we put in the probate inventory, and it may well be that the tax office will come along and say, well, I see what you say, tell me why it's right. Thank you, Mary.
Good luck, Mary. Thank you for your call. Hang on a sec, we'll get your details as well and put you in the draw for Friday week's party. Kylie is calling in Arthur's Seat. What did you want to ask, Kylie?
Good morning, guys. Thanks for taking my call. I have there's a planning application that has gone to the Minister for Planning under a development facilitation program through the Significant Economic Development Program. So
you said that with a sigh, didn't you, Kylie?
Far out, yeah. That means they're bypassing the council of Mornington Peninsula Shire Council. So there's no way for the community or the constituents of that council to make any submissions to object to it.
You could make submissions to the minister.
Okay, we can make submissions to the minister, but there's no third-party right. So if the minister approves the application, we can't go to VCAT.
That's right.
What I... Yeah, so it just stops there. So what I'm saying is, what is the VCAT equivalent of when something goes to the minister and they approve it?
I'm going to take that as a question on notice, Kylie. Let me explain that there are sometimes administrative law relief available, but it requires an application to the Supreme Court, and the assertion that you make is that the minister reached the wrong decision as a result of it could be a mixture of both of these, taking into account irrelevant considerations or failing to take into account relevant considerations. So that's the way the argument runs. The minister got it wrong because the minister took into account stuff that shouldn't have been taken into account or failed to take into account stuff that should have been. Now, it's called a prerogative writ. I think it's mandamus. But I'll take that as a question for next week as to whether that's open to you. But it's hideously expensive, Kylie. And if you lose, you can sell your house and you won't be anywhere near the problem.
But
Great. Thanks for that.
We'll
really
make that homework, Kylie.
It's a homework, Kylie. For
Thank
next
you.
week. Yep.
And David, part of your homework, there are certain, what's the word for it? There are certain rail lines planning can go on for which you have very, very limited or almost no recourse or appeal.
And that's become more prevalent in the last 2 to 3 years as we're trying to build the economy in the state. And I do a little bit of work for some developers, and we're just simply finding councils can't get the staff, so they can't process your application. Or alternatively, a council will say, "Don't like the colour of the front door. I think you need to change it." And you just think, "I'll go away."
Broader conversation, perhaps for another day. Terence is in Richmond. You're a first-time caller too, Terence?
Yes, I am, as it happens. Thanks for taking my call.
Pleasure. Go for it.
I purchased the house that I live in almost 4 years ago, and during that time hadn't received a rates notice from council, but yesterday received a notice from the council for $10,000, and it has an amount of $7,500 called balance brought forward, and then the rates for the coming year. Are they able to backcharge?
Yes.
They can.
So my question would be, I would be going to the council and saying, why don't you just give me the last 3 years? What happened to them? And they will have records as to when they changed the address and what it was changed from and to and all the rest of it. And then you might go and ask them to enter into an instalment arrangement in respect of them.
So it's not like the utilities companies that they can't, I understand this.
No, in the event
because you heard our water company story and you're wondering if they could charge that far back.
Correct.
Yes.
Right.
They can, Terence. They took away your rubbish.
What did you think was happening, Terence, with the rates?
I don't know. I just thought I was going under the radar and it's somehow fallen off the books.
Good luck.
Thank you.
Good luck. Be interesting. They go on instalment plans often, councils, for those sort of things? I don't know.
They're reluctant, but it doesn't mean they won't. I mean, Terence comes along. Or if you don't get what you want, then I would be going to the Ombudsman, the Victorian State Ombudsman, and saying, this, to a very large extent, is an issue of Yarra Council. They didn't send me rate notices. Yep.
Yeah, I'd give that a try. You might not get the debt wipe, but you might an instalment plan.
I wasn't suggesting that the Yarra Council should go unfunded, but rather it should be an instalment arrangement. For
David's running on a defund the council platform, not defund the police, defund the council. And Justin's in St Kilda West. What did you want to ask, Justin?
Oh, thanks. I engaged an architect, builder, engineer and surveyor to do extensions and renovations to my house. While the work went on, two neighbours complained that the excavation that my builder did had caused serious damage to their houses.
Did your building surveyor require protection work?
Yes.
And was that protection work done?
As far as I know, yes.
And did you take out insurance for the protection work?
No.
It's interesting. There's a requirement under the Building Act that if you're doing protection work, there should be insurance in place.
Well, the builder did the protection works and took out insurance. And neighbour A, who's my immediately adjacent neighbour, put in a quote to the builder to do the repairs. The insurance company for the builder agreed that was reasonable, paid them out, and it was all fixed. The second neighbour, neighbour B, who is more remote from my property, put in a quote roughly 10 times the first neighbour A, And
my
naturally, the insurance
guess-
company refused to settle.
My guess, Justin, is that the building surveyor didn't think any protection work was required for building B.
Building,
For owner B. Owner A was the one immediately adjacent.
correct.
Building B is the one further away. My guess is that the building surveyor didn't think that building was in any way relevant to your building work.
So if the insurance company refuses to settle, what's happened is owner B has now taken out proceedings against me in the Building Appeals Board.
Yes.
And the insurance company or the builder is listed as an interested party.
Definitely.
And the insurance is still connected to the case, but they're refusing to settle, and it's beginning to look as though the whole schmozzle will land on my lap.
No, your argument is that whatever you're found to be responsible for is the responsibility of the builder. So you're looking for a flow through of the claim.
Right.
No. So you're coming along and saying, look, I did everything that I was required to do. I've been properly engaged absolutely everybody. One of the issues from Building B's point of view is when you do protection works, you do what's called a dilapidation report.
Yes.
So I come and have a look at how many cracks you've got above the windows in your lounge room, and I come back after the work's finished and we work out whether they've got bigger or smaller. So one of the difficulties that Building B is going to have is establishing the quality of the premises before you started work.
Yeah.
But you're stuck in the middle, Justin. You got up in the morning and someone decided to sue you.
So what are his options?
Well, he has no way. Well, he's locked in. He can fold and sell the house and move out, or he has to engage, or he tries to do a deal with the builder and the builder's insurer to take on the matter.
Right.
Yep.
That's where
That's where I would be going.
Right.
Yep.
David, thank you very much. You've got a bit of homework there.
Thank you, Brad.
David Whiting answering your questions every Tuesday.